So as I have already mentioned, the method of proving a contradiction. However, there is slight difference in proving an omission before the trial court. In order to prove an omission which amounts to contradiction, the omission will first have to be converted into a contradiction. Now, so let us understand how an omission which amounts to contradiction can be proved during the trial. So let us understand by an example. If X makes a statement before the police that when I arrived at the scene, I saw A running away, chased by B and caught by C. Whereas in the witness box, he improvises and says that when I arrived at the scene, I saw A take out a dagger from his pocket, stab D in his chest and run away. He was chased by B and caught by C. Now this is an example of omission of two facts in the statement made before the police. One is that A takes out a dagger from his pocket, and second is that A stabbed D in his chest. Now these two statements were not made before the police, but however, he improvises his statement and makes such a deposition before the court. Now in this case, a cross-examiner will have to first bring out a contradiction, and then the procedure as prescribed under section 145 will have to be followed. So in order to bring out a contradiction, he will have to ask that I put it to you that when you arrived at the scene, A was already running away and you did not actually see him take out a dagger and stab D as you have deposed. If he answers that no, this is incorrect, I saw both the events, then the omission is converted into a contradiction. So when he denies this suggestion, the contradiction is brought on record. And now the next question which will have to be asked is, if that is so, why is your statement to the police silent as to stabbing? He can answer that I stated both the facts to the police. Then the question should be that I am showing you from the original record your statement before the police where you have mentioned when I arrived at the scene, I saw A running away, chased by B and caught by C. He might answer that I had stated but the police did not write accordingly. Here by this technique, first the omission is converted into a contradiction and thereafter the contradiction is brought on record, and now the next step would be to ask the investigating officer or the person who had recorded his statement whether the witness had stated such things before the police. If he says that he had made the statement before the police, then the contradiction is proved and brought on record, and thereafter the testimony of the witness can be discarded through contradictions or inconsistencies. So I hope you have understood the concept of what is contradiction, when an omission can amount to a contradiction, how a contradiction can be proved, and how an omission can be converted into a contradiction and thereafter proved in accordance with the provisions of the Indian Evidence Act. This is a very important technique and must be followed. This is prescribed under the Evidence Act and it is mandatory to be followed. Otherwise, important inconsistencies and contradictions will not be able to be proved and will not be read into evidence.